Good evening, this is John Milburn for Laws 13010, Evidence and Proof, and tonight we're dealing with weeks 7 and 8 material. Basically, it's hearsay. When you're looking at any form of legal argument, be ready to argue. Now, that might seem an obvious statement. We're talking about a legal argument, so be ready to argue. But what do I mean by that? What I mean is that quite often when you're discussing law, when you're advancing an argument, when you're analysing something or critically examining the material, there may not necessarily be a right or wrong answer. There are shades of grey. So you need to look carefully to see the grey, and you need to be creative, you need to be inventive, and you need to then pursue an argument. Lawyers are very fickle, so you may find yourself arguing the exact opposite of what you argued with vigour the day before, depending on the nature of the case. So remember that if you start to stress about providing an answer, don't necessarily assume that there is a single correct answer, that there's a single correct way of getting to make the best marks you can. In other words, people could score very highly on a case, a review or a material or an argument, even though they come to completely different conclusions. I say there's no right or wrong answer necessarily with confidence. Many of the cases that you see in the High Court are split decisions. So there you have High Court judges that come to an opposite conclusion. And that's why it's best that you try to present your material in a manner which is persuasive, rather than necessarily trying to work on getting the right answer. It's not maths. Having said that, it is important, if your lecturer, your examiner wants you to provide an opinion and advice, that in the process of giving that advice, you actually make a clear statement as to what you believe the outcome will be. It might be wrong, but so be it, but be decisive in terms of what you do. Okay, well, that's just some general commentary. Tonight we're dealing with hearsay and some of the exceptions to the hearsay rule. We'll be doing that for a few weeks. One of the best places to look as a guide point as to what it's all about is, I think, Section 59 of the Commonwealth Evidence Act. You recall we looked at that last week, and there you'll see Section 59, and it contains the flowchart material, which is very useful for determining admissibility issues. It's also a particularly good act in that it talks about, it provides examples. So the flowchart that I mentioned last week, I'm sure you've all seen, is on, well, page 35 of the print version. So it's at the introduction to Chapter 3, and Chapter 3 talks about relevance in 3.1 and hearsay in 3.2. So, of course, relevance is always a starting point. Something has to be relevant. Then we have to consider whether it's admissible as the second point. And this is where hearsay comes in. So, firstly, we've only got two online, so I won't pick on you, Samantha or Vivian, but feel free to jump in, make any comments or say anything. Samantha.
Yes?
You've unmuted your microphone.
Oh.
That's a red flag to say, yes, I've got something to say. And you're most welcome to do so, but I won't pick on you. So I guess the first thing we need to do is be very clear about what is hearsay. The second thing, we need to be clear about why we might use a statement which could be hearsay or could be not hearsay. Just mute the microphone there, Samantha, just for the moment. And remember, of course, that sometimes it is admissible to say something in court which would be otherwise hearsay if it is evidence relevant for a non-hearsay purpose. So have a look at Section 60. So it's odd, isn't it, that I'm saying that on occasions the same information can be admitted as evidence, and on other occasions the same information can be excluded on the basis that it's inadmissible. So the starting point is to identify that hearsay is basically material that is not admissible, but there are exceptions which will allow it to become admissible. So one of those, and we'll see it in section 60 of the Commonwealth Act, talks about evidence relevant for a non-hearsay purpose. Now, there's a leading case on this. I'll just pause for a moment in case either of you want to volunteer the name of the leading case that talks about the admissibility of material if it's for a non-hearsay purpose. I'm thinking subramanium. All right, so have you come across subramanium? Okay, it's an important case. And what that one does is it demonstrates very clearly the nature of a statement that might be hearsay in certain circumstances, or it might be admissible because it's for a non-hearsay purpose. So in Subramaniam's case, he was charged with a life penalty offence in Malaya, and his defence was duress. I was forced into doing something against my will, which constituted the criminal offence. Now, the facts were basically that a terrorist organisation essentially kidnapped Subramaniam, forced him to carry ammunition near a terrorist facility that carries with it a life sentence. He was charged with that, and he said, I was forced into it. If I didn't do what they wanted, they would kill me. That's what they said. Objection, hearsay. Do you see it? Objection, hearsay. If you want to prove, or if you want to say that, you have to call the people that made the statement. Think about it. So what, I have to find and subpoena the terrorists, the ones that threaten me with my life if I don't do as they say. Do you think I can find them? Do you think I can subpoena them? Do you think they will come to court and admit to that? So what, are you saying that I've got no defence? Anyway, it went through the appeal process. Ultimately, the court said, look, Subramaniam can say that. He can give that evidence about what somebody else said because he was doing so for a non-hearsay purpose. He was doing so to establish that the words were said, and he heard them with his own ears. He heard them. So on the face of it, he's relaying something that was through his own five senses. But we're not trying to establish in making that statement that the threat was real. We're not trying to establish that the terrorists would actually go through with the death threat. What we're trying to establish is that he heard those words, he heard those specific words in that circumstance, and that exactly, just that the conversation took place. But within that context, and what we're really interested in then is, and this is the non-hearsay purpose, what was the effect on him? What was his mindset as a result of hearing those words? I mean, if you think about it, it's a little bit like this. It might be, does your mindset change if you hear a round of ammunition going off, firearms, outside your house? You hear the noise, you testify, I heard the ammunition, I heard the gunfire immediately outside my house. It made me, this is how it made me feel, and this is how I reacted, and this is what I did as a result of hearing that. What's the difference between hearing gunshots and hearing someone say, do as I say or I will kill you? In both instances, it changes the way you feel, and it makes you do something that you wouldn't have otherwise done had you not heard the noise. One is a gunfire, another is words out of somebody's mouth. Okay? I hope that distinction is fairly clear. If you're watching this recorded session, make sure that you consider the difference between words that are said in court for a hearsay purpose or a non-hearsay purpose. One's inadmissible, generally speaking. The other is generally admissible. Okay, so that's Subramaniam. That's the case that I'd like you to consider within that context. It was from the 50s, but it was a really important case. And really, I suppose what we're saying there is that that was an example of direct hearsay. So it's someone who is giving original evidence of the facts that threats were made because they heard it directly. It's original hearsay. It's hearsay, but it's not admitted for a hearsay purpose. Next one is implied hearsay, and in your textbook there's a very good example of this. We'll just run through it briefly. A man phones his wife at home, hears a door opening in the background. His wife says, "Oh, hello, Peter." The line goes dead. The man rushes home. His wife is murdered. The statement of his wife is only implied hearsay. She didn't directly say, "Peter has just entered the house." But from her words, one could make the implication that Peter did enter the house. So we call that implied hearsay. I guess the third example is hearsay by conduct. That's pretty old-fashioned. I wouldn't worry about that too much. But the idea of hearsay by conduct is that people's actions speak loudly as their words, but really that evidence is admissible as direct evidence of what people saw. So it's not really likely to be something that's particularly relevant or important in practical terms. But do understand that difference between direct hearsay and implied hearsay in particular. So what we have discussed in part is the issue of circumstantial evidence and state of mind and intention. So the making of a statement can have some circumstantial value because the effect it is assumed to have on the recipient or what may be inferred regarding the mental state of the maker of the statement. So there's that distinction. So we're now talking about circumstantial evidence, state of mind and intention. And it's kind of tied up with this hearsay concept as well. So that's what we're dealing with. So looking firstly at the effect of making a statement is assumed to have on a recipient. So it's open for a jury in certain circumstances to consider a hearsay statement to determine the state of mind on the recipient. Well, that's subramanium, isn't it? The example in the text, someone discharges a shot into somebody else's face. The person who shot pleads accident. And a witness says he handed the shotgun to A and said, "Be careful, it's loaded." Now, that's evidence that goes to the assumed state of mind of the recipient, the first person who shot the gun. He must have known, as a result of hearing that the gun was loaded. So you can see that what was said by C, if told by A, was hearsay. But again, it's something which was said by a third person that changed the state of mind of the first person who heard it, the recipient. It's just like subramanium. It's a whole lot of range of examples that you can think about in that sense. Someone says something, it changes your state of mind. It might be hearsay, but those words, the mere fact that the words were said, may have some probative admissible value because of the way it changed the mind of the person who is, say, the accused. All right, so you might be wondering why the statement of C is regarded as hearsay at all. The answer is that it's not necessarily the case that prosecution are trying to prove, in that instance, by the statement that the gun was loaded. I mean, if they were trying to prove that the gun was loaded, then it's hearsay. But if they're trying to prove that it was simply said, then it's not necessarily going to be hearsay because it's evidence of what was said. It's not evidence that necessarily goes to prove the truth of what was said by the third party. Oh, I'm saying a lot of words, but I hope you're with me. I hope you're following it. Let's go back to some basics then. Firstly, what is hearsay? Bit tricky, although it's in a way it's simple as well. So hearsay is an assertion that's made by a person while giving evidence in a proceedings about what someone else said out of court. So when we're talking about hearsay, we're talking about out of court statements which are tended for the purpose of directly proving that the facts inserted in that statement are in fact true. Okay. So in Subramaniam's case, he was not making the statement of these words to prove that they would actually kill him. He was making the statements to say the words were said and this has had the effect on me. So the general elements of hearsay are things that are out of court, things that are statements, and things that, if the court allowed this to occur, would be provided as evidence in an attempt to prove that the actual words or the facts as asserted in the statement are correct. If we adopt that very broad definition of, and that was from Walton, so you can have a look at Walton 1989. If you adopt that very broad approach to hearsay, a few things flow from it. The first is that hearsay can be the traditional, this is what I think hearsay is. Okay, the traditional idea of hearsay, I think, that most people have is, well, if I go to court and I say that I heard somebody else say something, that's hearsay. And it's hearsay if the person in the witness box is trying to prove that what this other person said is actually true. I went to court and I heard Mary say that Jim did something. Now, if you're trying to prove that Jim did something because of what Mary said, that's hearsay, inadmissible. That's what we normally think about hearsay. But there are other things that are in reality hearsay because they fit within that broad definition of what is hearsay. So hearsay applies to out-of-court statements. Statements can be oral or they can be documentary. So a document contains information. And if you go to court and you refer to a document and say, this is what the document says, in an attempt to prove that what's on the document is actually true, then that's actually hearsay. You can call the person who created the document to give evidence. You can call an institution to authenticate a document if it's produced as part of that institution. I'm using that term very broadly. The acts use different terminology such as undertaking. But a document is basically hearsay because it's got material in it, which we call a statement, and those statements need to be verified by an actual person, generally speaking, in order for the court to accept as admissible evidence about what the content is in that statement. Now, the third type of hearsay is a little bit more obscure, and it's the hearsay of people actually making statements themselves in the past. So if you have a situation where someone has gone into the witness box and made a statement along these lines, I tell you now that from my own recollection, this occurred, that's fine. But if the witness then goes on and says, well, the day after, I told Jim and I told Mary and I told Ruth and I told David the same thing, then that really doesn't prove anything, does it? All that's not relevant because it's nothing that is directly related to the case. It's just me saying, well, I told other people about it, as if to prove somehow that because I told other people about it, that makes it even more true than me telling you by giving evidence. And if we take that example a little further, it becomes even worse because if the court didn't stop hearsay evidence, then Jim and Mary and David and Ruth or whoever it was that I said, they could come along to court and give evidence. Yes, he told me this on the day after it happened. And if you get enough people coming along giving that type of evidence, then the jury might think, wow, so many people have heard this, it must be true. It's like, I don't know, I'm not a Facebook person, but I imagine that there are a lot of instances where people repeat something, and because you hear it so often from so many people, it's all hearsay, but maybe if it's on Facebook, it must be true. But if you hear it enough, isn't there a dynamic that suggests to you, oh, it must be true? I mean, it might all come from the one source. It might be just one person who's made something up and disseminated this information all over the place. But because there's this chatter, everybody's saying it, you know, it's just a new, it's a human dynamic. It must be true. So that's one of the reasons we don't have hearsay. Evidence as admissible evidence. So the basic rule is, in court, witnesses testify from what they know, what they saw that's relevant at the time. We're not interested generally in what somebody else said. We're not interested necessarily in what's in a document. Don't come along and say, look, I read in the news that this is the case. No, we want to know what you saw, what you heard, what you touched, what you smelled, and so on. And it's even inadmissible as irrelevant if you say, well, I told somebody else the next day, as if to bolster your credibility. Okay, but there are these exceptions that we've talked about. So I got distracted there by talking about what is hearsay. And we were talking about the admissibility of statements that were made that may have an effect on the state of mind of the recipient. But it might also be that there is the issue of the state of mind of the victim, that is, as the recipient of the statement. Okay, so the example in your text is Bull against the Queen. It's 2000, 201 CLR 443. So what happened in Bull? In that case, the accused was allowed to call evidence of a telephone conversation between the complainant and one of the accused that suggested that she accepted an invitation to his house. The evidence is that in the telephone call, she was told that other men were present and she could participate to act out a sexual fantasy. The evidence was admitted as part of a defence of consent. And the evidence was admitted to show what the complainant's state of mind, and therefore intention, must have been when she agreed to go to the house. So in that case, Bull's defence was she consented. How do you prove that? Well, we have to prove it by introducing hearsay evidence, not necessarily to prove that she could in fact participate to act out this sexual fantasy, but to prove that this was her state of mind when she went to the house. This goes to prove her intention when she went to the house, and all of that goes towards establishing a defence of consent. So you can see that what we've talked about here are hearsay statements which have a bearing on a state of mind. The first set a bearing on the state of mind of the defendant. The second, the state of mind of the victim. But the same principle applies. So that is where we're talking about the state of mind of the recipient, either the accused or the victim. Contrast that to the assumed state of mind or intention of the maker. So Walton's case, I mentioned it briefly before, 1989 166 CLR 283 is important. And this is where we start to talk about issues of, circumstantial evidence, in this case in the context of a murder trial. And there are circumstances where a victim may have made a statement shortly before death that indicated the state of mind that they had or the intention that they had, right? So the first lot of cases, we're talking about the state of mind of the recipient of the information. Now we're talking about the state of mind or intention of the maker of the statement. And then we couple that with some presumptions, like a presumption of continuance, to indicate that if someone had a state of mind or intention at one stage shortly before something happened, then it's presumed to continue until the event did occur. So what happened in Walton? So in Walton, the victim's body was found in deserted country north of Elizabeth near Adelaide. Walton was convicted of the murder of the victim. That was his former de facto spouse. And Walton's new wife gave evidence. This is where it gets interesting. So Walton's new wife testified against Walton. Why did she do it? So she was not prosecuted. So she was not prosecuted as an accessory. And she said that Walton had discussed his plans with her, and Walton had stated his intention to set up a meeting with the victim in Elizabeth. So that's the first statement. Another witness, R, testified that she had been with the victim when the victim received a call from someone. The witness didn't know, but she knows that the victim received a call. And the Crown said the person who made the call was Walton, and the victim called her young son to the phone and said, "Daddy's on the phone." And at the end of the call, the victim told this witness R that the caller was Walton. So that's the second statement. So the question for the court is, would they allow the new wife and this witness R to give evidence of the statements? And the High Court admitted both statements. The High Court declared the intention of the victim to meet with Walton, described her state of mind when she made it. The presumption of continuance was then employed to infer circumstantially that she kept the appointment. And the second statement, the telephone call, was admitted as original evidence of the fact that both the victim and her son believed it was Walton. So that case is very important. So make sure you look at Walton. And importantly, of course, remember to refer to these cases in any examination tests or questions that you may have. They're important cases to have up your sleeve. Another one is Pollard. Pollard against the Queen, 1992, 174 CLR 558. This has anyone watched Rake? Have you seen Cleaver Green? Right, it's a really good show. Anyway, this was kind of out of Rake. There was something very similar to this as an episode. So Politan against the Queen. And notice that I've given you the CLR reference. You know why I'm giving you the CLR reference rather than, say, the ALJR reference? Do you know why? The significance of the CLR? Because that's the authorised report. So when you're citing material, always try to cite the authorised report. In the High Court jurisdiction, it's the CLR. Anyway, Pollard, we'll just quickly talk about that and then I'll keep moving on. So Pollard was charged with murdering, let's say, S. And the Crown alleged that Pollard intended to murder W. The Crown alleged that A hired Pollard to murder W, but A died before the trial. And A had made various statements that implied he knew all about the murder and that the wrong person was killed. So these people who heard this statement about the murder and it was the wrong person who were killed were in company of A when he received a call from someone, and during the call A became really angry and said, "You'll get the rest of the money when you do the job properly." Put the phone down and told these other people that the caller was Pollard. So the question for the court was this: would they allow Mr. and Mrs. B, they were the people that heard this telephone call at the other end, to give certain evidence that was important to the Crown case? Would they allow them to give evidence of the statement by the deceased, whether the telephone call is an exception to the rule against hearsay? And the High Court said that the evidence of Mr. and Mrs. B in hearing this call involving the now dead person A was admissible. The evidence showed that the person on the other end of the line was Pollard, and therefore, by circumstantial inference, Pollard was the killer. Pollard was the one who got it wrong and killed the wrong person. Okay, I hope that's making some sense. So read Pollard, read Walton, make sure, of course, you read Subramaniam. They're really important cases in this area. So mostly this is dealt with through statute now, of course, but remember that the common law exceptions may apply, and have a look at some of those exceptions. Re gestae, declarations by a person now deceased, declarations about health, fitness and mental state, about statements in a previous proceeding, and informal statements. I'll just briefly mention some cases to look at. In terms of re gestae, do you know what re gestae is? So have a look at that. So the principle underlining re gestae is this: it's an exception to the hearsay rule if an utterance made by a person at the very moment of critical events is likely to be genuine because they were made, the courts say, in the agony of their moment before an opportunity arose to invent something. So the elements of re gestae exception will allow this hearsay evidence if the utterance was contemporaneous with the event it described and the event dominated the mind of the utterer to the exclusion of any opportunity for quiet reflection. In other words, it was so overwhelming, it was so spontaneous, it was so contemporaneous that what was said is probably going to be right. So we'll allow that as an exception to the hearsay rule. That's the re gestae exception. This is common law. Have a look at Ratton against the Queen, 1972, Appeal Court 378. In that case, he was charged with shooting murder of his wife. He said, no, it's an accident. Privy Council said the Crown could adduce evidence of a telephone call made from the family home only 5 minutes before the shooting. A woman was in a hysterical state and said, get me the police, please, hung up. And the Privy Council said the evidence of the call was not hearsay, but if it was, it still fell within the re gestae exception. There's a recent decision on re gestae, if you really want to have a look at this for an up-to-date case in Queensland. Have a look at Brown against Holzberger. That's B-R-O-W-N, Brown, against Holzberger, Holzberger. The citation is 2017 QSC 54. And it deals with the application of the re gestae exception to the rule against hearsay to a comment made by a plaintiff. So this is a civil case shortly after a motor vehicle accident that had injured him. And determining whether or not the state was admissible, Justice McMeekin considered the possibility of concoction or distortion and the natural tendency to justify actions in one's eyes. So that's just an interesting case for you to have a look at. I won't go through it in any more detail now. I'll also leave you to read the other common law exceptions that are referred to in your text. Oh, you're doing well. You're both hanging in there. Thank you. I appreciate it. I'll just take a break for a moment. Any questions, comments? All good? All right. So let's continue now into week 8 material. So in week 8 material, we have issues to do with admissions and confessions. Now, admissions are generally, if you like, for want of a better term, civil matters, civil actions, and confessions relate to criminal matters. So there is the possibility of formal admissions in criminal cases, which is section 644 of the Criminal Code, Queensland. And the only condition there is that the admission needs to be made in open court. So that's used in practice to deal with certain procedural matters. So, for example, in a rape trial, if the accused admits to having had intercourse with the victim, then that admission can be made formally in court under section 644 of the code. Then the argument is all about whether she consented or not, for example. So it saves having to deal with certain things. So confessions relate to an acknowledgement of guilt, don't they, in criminal law trials? And it can be full confession, which is typically a plea of guilty then as a result of that, or it can be a partial concession of the Crown case. So have a look at section 81 of the Uniform Evidence Act, which deals with position in the Commonwealth jurisdiction. So admissions and confessions. Admissions can be made in several ways. Now this is to do with civil matters, or it can be made in criminal matters if it's a formal admission, section 644. So admissions can be made by a direct statement in oral or written form, or by failing to deny an allegation which, where it be reasonable to expect a denial. That's only relevant in the civil jurisdiction, or sometimes by evidence of a consciousness of guilt and running from a scene or telling lies. Have a look at Edwards against the Crown, 1993, 178 CLR 193 in that regard. So, but there are certain rules that allow for confessional evidence to be admitted, which is, of course, an exception to the hearsay rule. So if we think about the hearsay rule, what we're saying is it's an out-of-court statement tended for the purpose of directly proving the facts are true. In making a confession, we are actually trying to prove, by leading that evidence, that the person who made the statement out of court is actually a true statement. If someone confesses, admits to doing something, then the law says it's likely that they're telling the truth. Otherwise, why would they make such a concession? Why would they make such an admission? So a good case to look at now is Pollard against the Queen. That's 1992, 176. The court said that it must establish the admissibility by looking at the balanced probabilities as to whether it was admitted or not, and must also consider issues to do with illegality or improper obtaining of evidence. And just as an aside, when you're talking about improper evidence or illegal evidence, think about cases such as R against Lee from 1950, think about Bunning and Cross, and think about Cleland case from 1982. Right, so what do we do? So let's assume that we've looked at Pollard and we've got an idea of what that case is all about. And here are the steps that you need to follow. I'll give you 4 steps that you need to follow in practice to determine the admissibility of confessional evidence. So number 1, did the party make an admission? If they didn't make any form of admission or a confession, then there's nothing to see here. Number 2, did the party make the admission voluntarily? In other words, we're only interested in voluntary admissions. So we need to consider whether the admission was obtained as a result of oppressive conduct. If it was, it's not admissible. We need to consider whether the admission was obtained through an inducement. If it was, it's not admissible. The third thing is, if the admission was voluntary, so if the admission was made, number one, and number two, if the admission was voluntary, number three, can the judge exercise a discretion to exclude it anyway? And that's what we call the Christie direction. In other words, the evidence has to have been obtained fairly, so there's a fairness discretion, and in accordance with public policy. So there's what we call a public policy discretion. In other words, okay, let's assume that there was an admission made. Let's assume the admission was made voluntarily, but let's assume it was obtained in circumstances where police had not followed the law. There's a public policy discretion which would suggest that we should not allow it anyway, because we don't want to encourage the police to break the law in order to secure a confession or an admission. So it may have been voluntary, but we're still not going to let it in. And it may not be fair to let it in either. Number four is, if neither of those discretions apply, to exclude the admission, it is admissible, subject to this overriding discretion to exclude the evidence where the prejudicial impact is greater than its probative value. I really want you to focus on that phrase and use it a lot. It's bandied around a lot. So is the prejudicial impact or prejudicial impact greater than its probative value? The leading case there, have a look at SOS Field. SOS Field and Pavic were cases heard together by the High Court. Citation for SOS Field, 1998, 198 CLR 159. Now, in terms of admissions, also consider a case of Ireland, R against Ireland, 1970 126 CLR 321. And in that case, the court considered the admissibility of questions and responses where there was no answer or a refusal to comment. All right, so you're doing well. Other than that, just generally think about whether there was oppression or oppressive conduct in obtaining a confession or an admission. And the fairness discretion always applies. I mentioned earlier R against Lee. Also think about McDermott, because the McDermott Lee discretion is one where a trial judge has a discretion to reject a confession or other incriminating statement made by accused if through the statement could not be held to be inadmissible as evidence. In all circumstances, it would be unfair to use it as evidence against the accused. So what we're really trying to say is that this fairness discretion might be invoked in circumstances where someone is entrapped or misled or persuaded to answer questions in a particular way. So it's all got to be fair. All right, so in SOS Field, for example, the accused made an admission, made it voluntarily to a witness, but the accused didn't know that the witness was a police officer. And in that case, it was held to be inadmissible confessional evidence because the police officer, having formed an opinion that SOS Field was guilty, should have charged him and administered the rights to silence in the ordinary manner before effectively receiving or obtaining this confession that was set up through this technique that was used in that case. All right, so I'll leave you with this thought. Also consider the Christie direction in general terms. And the Christie direction, so just have these sort of written down, ready to go, but the Christie direction is a general discretion available to a court to exclude evidence which is highly prejudicial and has low probative value. And what we're looking to do there is determine whether the probative value is outweighed by the potential unfair prejudice to the accused. And that's very wide. That can be for all sorts of things. Like at a basic level, criminal histories are unfairly prejudicial to the accused under our law, even though to some degree they might be seen as having probative effect. Likewise, extremely gruesome photographs that the prosecution might want to tender might be excluded on the Christie discretion on the basis that whilst they might be probative, their prejudicial effect is substantial and might overwhelm the judgment of the jury in terms of a fair balance. Okay, so before we wrap up for this evening, are there any questions about what we've talked about? All good? Samantha, fine. Vivian, all good? All right. Thank you very much. Good luck with your studies. Please ask questions through UCrew. Good luck with your second assessment. And I know you're working through those examples week by week. Keep going. All the best. We'll see you next time. Bye then.